Hello students, I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. Today I will be discussing the topic of the constitutional protection of the right to protest in India. Those who make peaceful revolution impossible will make violent revolution inevitable. The quote is given by John F. Kennedy. Introducing the topic, the right to protest is a fundamental human right that allows people to express their opinions, grievances and demands for change in a peaceful and collective manner by exercising their right to freedom of expression, assembly, association and participation in public affairs, subject to a reasonable restrictions imposed by the state in the interest of sovereignty, security, public order, morality and other legitimate grounds. According to Amnesty International, the right to protest is under attack and must be protected from those who are afraid of change and want to keep us divided. The organization launched a global campaign called Protect the Protest to expose when the right to protest is violated and support movements worldwide as they thrive for positive change. The campaign calls on governments to send a clear message that protesters should be protected and to remove unnecessary barriers and restrictions to peaceful protest. Civics, a global alliance of civil society organizations and activists, developed a protest resilience toolkit to help people understand and exercise their right to protest. The toolkit defines the right to protest as a combination of the rights to the freedom of association, peaceful assembly and expression. It also provides 10 general principles that apply before, during and after a protest based on international standards and best practices. The UN Human Rights Committee, which monitors how countries implement the International Covenant on Civil and Political Rights, issued a legal advice on a right to peaceful assembly in 2020. The advice clarifies the scope and content of the right to peaceful assembly as well as the obligations and responsibilities of state and protesters. It also addresses emerging issues such as online assemblies, counter demonstrations and the impact of COVID-19 on the right to protest. Coming to the historical background of right to protest. The freedom struggle of India was marked by various forms of protests such as civil disobedience, non-cooperation, satyagraha, boycott and strikes led by prominent leaders like Mahatma Gandhi, Jawaharlal Nehru, Bhagat Singh, Subhash Chandra Bose and others. These protests challenged the legitimacy and authority of the British government and mobilized the masses for the cause of independence. After independence, the right to protest in India continued to be exercised by various groups and movements to voice their dissent or opposition against the government policies or actions, or to demand social, political or economic changes or reform. Some examples of such protests are the Quilt India movement, the Telangana rebellion, the Naxalite movement, the JP movement, the emergency protest, the Mandal Commission protest, the anti-corruption movement, the anti-car protest, the farmers protest and others. Thus, these rights were accorded a very high position following the experience of the long freedom struggle against the British. Next, coming to the constitutional provisions. The constitutional provisions that guarantees the right to protest in India. The right to protest in India is not explicitly mentioned as a fundamental right in the Constitution of India, but it can be derived from following provisions that grant the citizens of freedom of speech and expression, the freedom of assembly and the freedom of association. First is Article 19(1) subclause A of the Indian Constitution guarantees the citizens the right to freedom of speech and expression, which includes the right to express one's opinion, dissent, criticism and grievances against the government or any other authority through various modes and mediums such as speech, writing, arts, media, etc. Article 19 Clause 1 Subclause B of the Constitution of India guarantees the citizens the right to assemble peaceably and without arms, which implies the right to gather and demonstrate in a non-violent and unarmed manner for a common cause or purpose, such as protesting against a law, policy or action of the government or any other authority. Article 19 Clause 1 Subclause C of the Constitution of India guarantees the citizen the right to form associations or unions, which means the right to organize and join groups, organizations or movements that share a common interest, ideology or goal, such as protesting for a social, political or economic change or reform. These rights are essential for the functioning of a democratic system, as they enable the citizens to participate in the public affairs, voice their concern and demand, and hold the government accountable and responsive to the people. International law on right to protest. The right to peaceful protest is enshrined in the Universal Declaration of Human Rights of United Nations, which was adopted in December 1948. In international law, many treaties, especially the International Covenant on Civil and Political Rights, acknowledged the right to freedom of association, peaceful assembly and speech. These rights are indispensable for the exercise of the right to peaceful protest. Judicial activism. The case laws that have interpreted and upheld the right to protest in India are as follows. The Supreme Court of India and various high courts have recognized and affirmed the right to protest in India as a fundamental right that is inherent in a democratic polity. Some of the landmark judgments that have dealt with the right to protest in India are as follows. First is the case of Ramesh Thapar versus State of Madras. The Supreme Court held that the freedom of speech and expression includes the freedom of propagation of ideas, which is essential for the dissemination of information and opinions, and thus for the formation of public opinion on matters of national importance. The court also observed that the freedom of speech and expression is the foundation of all democratic organization and one of the basic conditions for the progress of the country. The next case is in Kameshwar Prasad versus State of Bihar. The Supreme Court struck down a rule that prohibited the government servants from participating in any demonstration or strike. The court held that rule violated the fundamental rights of the government servants under Article 19 Clause 1 Subclause A, B and C of the Constitution, and that the right to protest peacefully was legitimate and democratic way of expressing dissent and dissatisfaction with the policies of the government. In case of Himmat Lal K. Shah versus Commissioner of Police Ahmedabad, the Supreme Court held that right to hold public meetings in a public places is a part of the right to assemble peaceably and without arms under Article 19 Clause 1 Subclause B of the Constitution, and that the authorities cannot impose unreasonable restriction on the exercise of this right. The court also held that the authorities cannot deny permission to hold a public meeting on the ground of apprehension of breach of peace or public order unless there is a sufficient material to justify such apprehension. In case of Ram Leela Maidan incident versus Home Secretary Union of India, the Supreme Court held that citizens have a fundamental right to assembly and peaceful protest that cannot be taken away by arbitrary executive or legislative action. The court also held that right to protest peacefully is not only a safeguard for individual liberty, but also a cardinal feature of democracy, and that the state has a duty to protect and facilitate the exercise of this right. The court also laid down certain guidelines for the regulation and management of public assemblies and protest, such as prior notice, designated places, duration, etc. In Mazdoor Kisan Shakti Sangathan versus Union of India, the Supreme Court upheld the right to protest at the Jantar Mantar in New Delhi, which is a designated place for holding demonstration and rallies. The court held that right to protest is crucial for the expression of the voice of the marginalized and oppressed section of society, and that the state cannot impose a blanket ban on the exercise of this right at a particular place. The court also held that the state has to balance the right to protest with the right to free movement and right to live in a peaceful and clean environment of the resident of the area. In case of Amit Sahni versus Commissioner of Police and others, this case was related to protest against Citizenship Amendment Act 2019 that took place at Shaheen Bagh in Delhi, blocking a public road and causing inconvenience to the commuters. The Supreme Court held that right to protest is a fundamental right under Article 19 of the Constitution, but it is subject to reasonable restrictions and cannot be exercised in a manner that infringes the rights of others or cause public nuisance. The court ruled that public spaces and public ways cannot be occupied indefinitely by the protesters, and the administration and the police have the duty to ensure that such spaces are cleared and made available for the use of public. The court also observed that the protest should be held at designated places and regulated by authorities in accordance with the law and guidelines laid down by court in its previous judgments. In case of J.R. Prashar, advocate others versus Prashant Bhushan, this case was related to an allegation of contempt of court against the respondents who were accused of holding a dharna in front of the Supreme Court and shouting abusive slogans against the court and its judges. The Supreme Court dismissed the contempt proceedings initiative against the respondents on the basis of the petition, as it found that the allegations were not substantiated by any evidence and that the petitioners had failed to follow the procedure prescribed by the Contempt of Courts Act 1971. However, the court issued a notice to one of the respondents who had made some statements in her affidavit that could amount to contempt of court. The court held that right to protest and criticize the judiciary is a part of the freedom of expression, but it is not absolute and cannot be used to scandalize or lower the authority of the court or to interfere with the administration of justice. Reasonable restrictions. The reasonable restrictions that can be imposed on the right to protest in India. The right to protest in India, like other fundamental rights, is not absolute and is subject to reasonable restrictions that can be imposed by the state in the interest of sovereignty and integrity of India, the security of the state, the friendly relation with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence. These restrictions are provided under Article 19 Clause 2 and 19 Clause 3 of the Constitution of India, and they are meant to ensure that the exercise of the right to protest does not infringe upon the rights and interests of others or endanger the public peace and order. Some of reasonable restrictions that can be imposed on the right to protest in India are: the state can regulate the time, place and manner of holding a protest, such as requiring prior permissions, imposing conditions, specifying the duration, etc., as long as regulation is not arbitrary, discriminatory or excessive and is based on valid grounds and material facts. The state can prohibit or disperse a protest that is violent, armed, unlawful or disruptive of the normal functioning of the society, such as causing damage to the public or private property, obstructing traffic or essential services, creating nuisance or disturbances, etc., as long as prohibition or dispersal is done in a proportionate and minimal manner and is in accordance with the law and the principle of natural justice. The state can take legal action against the organizers or participant of a protest that violates any law or infringes upon any right of other, such as imposing penalty, initiating prosecution, etc., as long as such action is fair, impartial and consistent and is subjected to judicial review and remedies. Next, I will be discussing right to protest of lawyers. The question that whether the right to protest extend to lawyers who are officers of the court and have a duty to uphold the law and administration of justice has been answered by the Honorable Supreme Court in a catena of judgments. The Supreme Court of India has consistently held that lawyers have no right to go on strike or to give a call for a boycott, though a token strike is permissible. The court has also held that such action by lawyers amount to professional misconduct and can invite disciplinary action by the Bar Council of India or the state bar councils. Some of the landmark judgments of the Supreme Court on this issue are: in ex capital Harish Uppal versus Union of India, the Supreme Court held that lawyers have no right to go on strike or give a call for boycott, not even on a token strike. The court observed that right to protest is a fundamental right, but it does not include the right to strike or boycott the courts. The court also observed that right to access justice is a fundamental right of the citizen and it cannot be denied or delayed by the lawyers by restoring to strike or boycott. The court further observed that the lawyers have a duty to the court, to their client and to the society, and they cannot strike their responsibility by taking the law into their hands. The court also laid down certain guidelines for the bar councils and the courts to deal with the issue of strike or boycott by lawyers, such as taking suo motu actions, imposing costs, initiating contempt proceeding, etc. In case of common cause, a registered society versus Union of India, the Supreme Court reiterated its view that lawyers have no right to strike or boycott courts and that such actions are illegal and unethical. The court also held that the Bar Council have a statutory obligation to prevent and prohibit such action by the lawyers and to take appropriate disciplinary action against the erring lawyers. The court also held that the court have the inherent power to take suo motu cognizance of such actions by lawyers and to pass necessary orders and to ensure the smooth working of the court and the administration of the justice. The next case is Krishna Kant Tamrakar versus State of Madhya Pradesh. The Supreme Court held that lawyers have no right to abstain from court work without any reasonable cause and that such action amounts to contempt of court. The court also held that bar councils have a duty to ensure that the lawyer perform their professional duties and do not indulge in any unprofessional conduct. The court also held that courts have the power to debar the lawyers from appearing before them if they are found to be guilty of contempt of court or professional misconduct. Thus, it is clear that right to protest of lawyer is not a constitutional right and that it is subject to the limitations imposed by the law, the ethics and the interest of justice. Lawyers as an officer of the court have a higher responsibility to uphold the rule of law and the dignity of the judiciary, and they cannot use their position to disrupt the judicial process or to deny the right of these litigants. Lawyers as citizens have the right to express their views and opinion on any matter of public interest, but they have to do so in a peaceful and lawful manner without affecting their professional obligation and duties. The power of non-violence. The first is the Chipko movement 1973. The Chipko movement was a remarkable manifestation of Gandhian non-violent principles. It involved people, especially the women, resisting deforestation by hugging trees. The movement galvanized thousands of people across India to support the cause of environmental conservation. For more information on who initiated the Chipko movement, please refer to the link which is given below. Next is the Narmada Bachao Andolan 1985. The Narmada Bachao Andolan was a seminal movement that challenged the dominant paradigm of development project. It was a protest against the construction of a large number of dams along the Narmada river which threatened the livelihood and cultures of the indigenous people, farmers and fisher folk. It brought together a diverse coalition of activists, environmentalists and human rights advocates. The movement succeeded in obtaining a stay order from the court on the development of the dam. Next is the Lokpal Bill of 2011. The Lokpal Bill was a historic campaign that mobilized the nation against corruption. It was sparked by the hunger strike of Anna Hazare, a veteran anti-corruption crusader at Janata Mantar. The campaign demanded the enactment of a strong anti-corruption law that would create an independent ombudsman to investigate and prosecute cases of corruption. The campaign was a rare phenomena held witnessed the participation of millions of people from all walks of life. The next movement is the Nirbhaya movement 2012. The Nirbhaya movement was spontaneous and massive uprising that erupted in aftermath of the brutal gang rape of a young woman in Delhi. The movement demanded justice for the victim and an end to the culture of violence and impunity against women. The movement compelled the government to enact new laws and policies to ensure the safety and dignity of women. The government also launched the Nirbhaya Fund to provide financial support for various initiatives for women's protection. The farmers' protest. The farmers' protest in India started in November 2020 when the central government passed 3 laws that aim to liberalize the agricultural sector and allow the farmers to sell their produce outside the state regulated market. The laws are the Farmers Empowerment Protection Agreement of Price Assurance and the Farm Service Act 2020, the Farmers Produce Trade or Commerce Promotion and Facilitation Act 2020 and the Essential Commodities Amendment Act of 2020. The farmers, mainly from the northern state of Punjab and Haryana, opposed the laws, fearing that they would lose their bargaining power and be exploited by big corporations. They demanded the repeal of the laws and the guarantee of a minimum support price, that is MSP, for their crops. The protests escalated into a nationwide movement with thousands of farmers campaigning at the borders of Delhi and blocking several highways. The government tried to negotiate with the farmers' union, but the talk failed to reach a consensus. The Honorable Supreme Court of India in Rakesh Vaishnav and others versus Union of India and others intervened in the matter and stayed the implementation of the laws in January 2021. It also set up a 4-member committee to hear the farmers and submit a report. However, the farmers rejected the committee, saying that its members were biased in favor of the laws. The court also upheld the farmers' right to protest, but said that they could not block the roads and affect the public orders and movement. It asked the farmer to choose between the court or the road, implying that they could not protest while the matter was sub judice. The protest continued for almost a year despite the COVID-19 pandemic and the harsh weather conditions. The farmer faced several hardships such as police brutality, water cannons, tear gas, internet shutdown and media censorship. The protests also witnessed some violent incidents such as the tractor rally on Republic Day and the attack on the convoy of the Deputy Chief Minister of Haryana. The government finally agreed to repeal the laws in November 2021 after a meeting with the farmers' leader. The Prime Minister of India announced the decision in a televised address, saying that he had failed to convince the farmers and apologized for the inconvenience caused by the protest. He also said that government would form a committee to address the issue of the farmers and ensure their welfare. The farmer welcomed the decision, but said that they would not end the protest until the laws were formally repealed by the parliament and their other demands were met. Concluding the topic, I can say that protests are a powerful way of bringing positive social change and advancing human rights in the world. They also help to create a more engaged and informed public that can participate in a civic life. Protests are especially important for the marginalized and underrepresented groups who can use them to voice their concerns and demand their right. Protests also strengthen democracy by allowing people to directly influence public issues and hold governments and other institutions accountable for the action. Protests are thus an essential part of the civic, political, economic, social and cultural life of all societies. However, protests are not always peaceful and constructive. Sometimes they can turn violent and cause harm to people and property. Protests can also be influenced by political agendas of opposition parties who may use them to undermine the government or gain popularity. Protests can also affect the daily lives of the people who are not involved in them by disrupting the traffic, blocking the public space or creating noise and pollution. Protests are thus not always a positive or effective way of expressing opinion or demand changing. Therefore, the right to protest in India is a constitutional right that is derived from the freedom of speech and expression, the freedom of assembly and the freedom of association. It is a vital right for the citizen to express their views and demands and to participate in democratic process. It is also a right that has been recognized and upheld by the judiciary in various cases. However, the right to protest in India is not unlimited and is subjected to reasonable restrictions that can be imposed by the state in the interest of the public order and the rights of others. Therefore, the right to protest in India must be exercised in a responsible and peaceful manner, and the state has to respect and protect this right while maintaining a balance between the right to protest and the other rights and interests. Lastly, I want to say, if you are neutral in situation of injustice, you have chosen the side of the oppression. If an elephant has its foot on the tail of a mouse and you say that you are neutral, the mouse will not appreciate your neutrality. Desmond Tutu, thank you and have a nice day.